Hey, you guys, my clock says 6:30, so I'm going to get ahead and get started. I'm really happy to have you guys here. Thank you for coming to the meeting. Let me just do some housekeeping stuff. First, let me introduce myself for you guys who haven't met me yet. My name's Chris Haw, last name H.A., like my funny guy. I'm an attorney here at the Thrash Carroll Vanway Law Group. My specialty at the firm is I do just what we're talking about tonight. Helping trustees get a hold of their trusts, setting them up, and managing them. I'm a board certified in estate planning, so that's the highest level credential we can get here in Texas. And I'm also a certified financial planner. So incidentally, I can help you with your investments. And in my past life, I did a lot of income tax returns. We won't be talking about taxes a lot tonight, but I can do that too. So what we're doing tonight is a presentation on Successor Trustee School, what your successor trustees should know. This is the same advice I give my own clients when they hire me to help with a trust. Administrative items. What we're going to do is, for questions, go ahead and look for your chat box in your interface. I've already got some sample text in the box. So if you want to ask any questions, that's the best way. So that way I can scroll up and see your questions. 2, we're going to be recording this presentation so that you can watch it later and refer to it or share it with other people. So I want you to know, if you're waiting to tell me that you're an international crime lord, don't tell me right now. Wait until later. Connie, don't give it away. I see you smiling over there. Okay.
I'm an intergalactic crime lord.
Intergalactic crime. Oh my goodness, Connie. And then finally what I'll do is I'm going to mute us until we get to the question sections, and then it is game on. Just let's go. I'm going to try to make this participatory so you can ask a lot of questions. And finally, as an attorney, I do have to give a disclaimer. This is informational and general in nature. So if you want specific advice for your specific situation, please go ahead and shoot me an email. I'll give my email address in the text box later at the end, and you can shoot me a personal question for specific questions for your specific case. No attorney-client privilege here, no confidentiality. That said, it looks like I got a bunch of happy faces here. Let's get started. Here's our overview. I think you can see my laser pointer on the screen right now. We're going to go over, how do I know I've got a trust? Why do I want to use a trust? How do I set it up and get it going? And what do I do once I'm in charge of the trust? This presentation is, once I finish it, I realize it's quite long. So this is going to be part 1. We're going to go as far as we can and just see where we end up. Please feel free to fill my chat box with a bunch of questions and I'll try to help. So, first question. How do I know I have a trust? What is a trust? How do I know I'm looking at a trust? Aside from cheating and looking at the top of your document and seeing that it says trust, the way that you know you've got a trust is that a trust is defined as a way of holding property where you've got 3 relationships to the property. And we'll go over those. You've got the grantor who contributes property to the trust. You've got the trustee who holds title to the trust. And then you've got the best person, the beneficiary, who receives assets from the trust. So let's take a look at those people a little more specifically. The grantor, or depending on which attorney you ask, because sometimes we use different names for the same person, you'll see them called grantor, trustor, settlor. The grantor is the person who has the assets and gives them to the trustee to hold in trust. This is typically the person who's worked really hard, saved a long time, has got some assets they want to pass on to somebody else. So they're the ones who give assets to the trust. And you've got some examples there at the bottom. Usually if they've got cash, they deposit the cash into the trust checking account. Or if they've got real estate like Scarlett here, they file a deed that transfers the real estate to the trustee. And I'll show you the next part. Who is the trustee? What does the trustee do? I'm going to reveal a bias to you guys. I usually represent trustees, so to me, every trustee is a superhero who's working really hard. What the trustee does is he takes the assets from the grantor and he holds them for the benefit of the beneficiary. His job is to take a hold of the assets, maintain them, pay the taxes of the trust, pay the insurance of the trust, and then follow the instructions that the grantor left for him in the trust document. And you'll notice he's a very hardworking guy because he can be sued by the beneficiaries if he doesn't follow the instructions of the trust. And if they sue him and win, they can try to get assets from him up to the value of the trust and sometimes even more. So in my opinion, when I represent trustees, these are hardworking guys who are doing a lot of work and they have a lot of responsibility. So let's go to the next person, the best person, the beneficiary. If you have a choice of what you want to be with a trust, you want to be the beneficiary. You want to be the guy that the trust document says, give trust assets to this person. Typically, when the grantor creates the trust, he puts stipulations on how the beneficiary receives trust assets. Sometimes it's based on age. 21, give him $50,000. 25, give him $50,000. It could be for a specific purpose. College, first house, first marriage, starting a business, anything the grantor wants to put in the trust document. Or sometimes you see language with a standard like you've got there, health, education, maintenance, and support. And then finally, and we'll cover that later in some other examples, and then finally the beneficiary can demand a trust accounting from the beneficiary. What if the trustee is corrupt? What if he's evil? Oh, let me admit someone to our meeting. That's why I'm looking over here. I've got two screens. Admit. Sometimes you've got a trustee who's untrustworthy, so you could sue them and say, hey, you're mismanaging the trust assets. So the beneficiary can really hold the trustee's feet to the fire. So I know there's a lot of talking from me. Let me give you some examples and see how this plays out. Trust example number one, we've got Anakin. Anakin says, hey Ben, please hold my lightsaber for my son Luke until he is age 18. So we've got three people here. We've got Anakin, we've got Ben, and we've got Luke. Each of them has a role. One of them is the grantor, one of them is the trustee, and one of them is the beneficiary. So this is your part. I'm going to ask you this question. Based on what we know about trust now, what is Anakin?
Grantor.
I have one vote for grantor. I see at least 4 people saying grantor. Anyone else in the peanut gallery? The answer is grantor, and here's how you know. Anakin is the person contributing the asset in this case. He's saying, hey, I want you to hold this asset for somebody else. What is Ben? What is Ben's role in this trust?
Trustee.
You got it. You got it. Ben is the trustee because what is he doing? He's holding the asset for the benefit of Luke, right? So by process of elimination, Luke is the beneficiary here. Okay, let me give you guys another example. Trust example number 2, father. Hey wife, use this money to provide for my daughter's health and education for her lifetime. There is father, there is wife, and there is daughter. I think you guys were so fast at the last one. I think you guys already know the answers here.
Yeah.
What is father?
Grantor.
Grantor.
Yes, very good. What is wife?
Trustee.
Trustee.
There, you guys are crushing it. You guys are crushing it. And daughter, by process of elimination, is the beneficiary. Hey, if you guys haven't done so already, we've got a question in chat. Let me go take a look at it with you guys. This is from Ginger to everybody. And remember, if you want to ask a personal question, I'm going to give you my email address at the bottom of the meeting, so you can email me questions if you like. Are there limits on the types of trust that can be established? Can the trust establish eccentric limits of any variety imaginable? Oh, Ginger, I like that question because those are the kind of questions that keep me employed. Yes, when you write a trust, because it's your stuff, right? I'm assuming it's from the point of view of the grantor. At least here in Texas, there are some restrictions, such as a dynasty trust restriction that's outside the scope of this presentation. But you can really, what we call them is from beyond the grave kind of controls, where you can set really specific limitations. I think the litigators have told us about the most interesting ones, such as you get $50,000 if you graduate from college with a 3.7 GPA and a science degree. You can make it really specific. So I hope that helped, Ginger. I'm going to keep on going. So, philosophical question. Why use a trust? Now that we know what a trust is, it's a way to hold property. Why do you want to use a trust? If you open up the Wall Street Journal or the newspaper, you will hear about people using trust in all sorts of creative and inventive ways. For the purposes of estate planning, what we're doing here, we use them for three major purposes that you've got right there at the bottom. Avoiding the cost and expense of a probate administration when somebody dies, protecting the privacy of your assets when you die. And then last one, and I think this is the champion that often gets overlooked, is with a trust, you can create continuity of management. So if your first ball player dies, there's a backup that can immediately step in and say, all right, put me in the game, coach. I can manage these assets according to the trust. So let's look at each of those three in more detail. Number one, probate avoidance. So remember, when you die, this is what this first bullet here is talking about right here. The general rule is that when you die and you have an asset in your sole name, it doesn't say co-owner. It doesn't say transfer on debt. It doesn't say pay on debt. It just says Fred Smith. That's it. If you die with an asset in your individual name, the general rule is that that asset will be frozen when you die, once the custodian finds out that you are deceased. I'll use the example of a checking account. You have an account that is solely in your name. It has no transfer on death, no pay on death instructions. It's not co-owned with anybody else. Once the bank finds out that you're deceased, they're going to freeze that account. Because from the bank's point of view, there's one authorized signer on that account, right? They're only supposed to pay it to Fred. So once they find out Fred is deceased, they go, there are no more authorized signers on this account. We shouldn't pay it to anybody until we see a judge's signature saying this person has legal authority as determined by a judge to access that account. Otherwise, the bank is going to say, the money's not coming out. Contrast, you have a trust. you have the account properly set up in the name of your trust before you die. If you die and you're the grantor, you're the person who made the trust, and you die and your account is in the name of your trust, when the bank finds out that you are deceased, they'll say, okay, well, there's a backup trustee on this trust document. That backup trustee shows up at the bank with your death certificate and says, hey, look, the original trustee is deceased, but if you look at the trust document, I'm the backup trustee. Here's my driver's license to prove that I'm that person. The bank will say, okay, we verified you are who you say you are. You are named as the backup trustee in the trust. As long as you just fill out some paperwork, we will make you the new signer according to what the trust says. You do not have to spend 2 months and $4,000 going through the probate court process to get a judge's signature. You just prove that you're the backup trustee, and now you can sign for that trust checking account. Okay, you guys don't look lost in the video yet. I'll give you an example. Probate example number 1 with trust. Sue Ellen and JR buy a rental property together as husband and wife in their joint names. They're here in Texas, and it's community property. Because when you buy property as a married couple, it defaults to community property. JR dies very suddenly, mysteriously. So Sue Ellen is the surviving spouse. Can she sign for the rental property after her husband's death? What do you guys think? I'm going to unmute you guys, by the way, so that you can. What do you guys think? I know this one's harder than the last one.
Say no.
I've got one no. One no.
I think that the title to the property would have to be changed to her name only, and then she could.
Okay, I've got a conditional yes from Al. I'm going to keep you guys in suspense. I can see some of you thinking about it. Okay, I'll tell you. This is kind of a mean question. In Texas, in this case, a married couple bought property as husband and wife, so it's their defaults to their community property. So Sue Ellen owns half, JR owns half, right? So if JR dies, and remember, this house is in their individual names, right? Joint names. JR dies, Sue Ellen only owns half this house, half this rental property. So if she tries to sell the house, this rental property, a title company is going to get involved. And the title company is going to check the deed records and say, hey, the ownership of this house is 50% JR, 50% Sue Ellen. Sue, I see you here. You can sign for your half of the house. Where's JR? And she's going to say, JR is deceased. And the title company is going to say, okay, so you need to show us a judge's signature before you can sign for JR's half of the house. We need to see a judge's signature saying someone has authority to sign for JR's half of the house. So in this case, you had no trust, you died with property, so JR's half of the house got frozen. Let me give you a counterexample with a trust. Probate example number 2. JR creates a trust checking account. So it's a valid trust checking account. You can say it's properly set up. It's no problem. He sets it up. His trust says the current trustee of my trust is me, JR. And the successor trustee, the backup trustee, is Sue Ellen. JR, it happened again, you guys. JR dies again mysteriously. Is probate necessary? Do we need a judge's signature? Who can sign for the trust account now that JR is deceased?
Sue Ellen can.
Sue Ellen with a death certificate.
I've got one answer from Al. Sue Ellen with a death certificate. I'll tell you what, Al is right. Al is I've worked with Al before. He's very organized. He's very good at this. So you're right, Al, exactly. We've got a trust document here, right? And we've got an account that is in the name of the trust. So it's controlled by the trust document. So the original trustee dies. JR dies. Okay, that's normal. Trustees eventually die. But the trust document says, I've got a backup trustee. My successor trustee is Sue Ellen, right? So if Sue Ellen, just like Al said, if Sue Ellen shows up with a death certificate, she says, look, my husband is deceased. Here's my driver's license. I am in fact the Sue Ellen that's described in the trust document. The bank verifies her identity and says, yep, okay, looks good to me. You'll probably just need to sign some paperwork, but once we have gone through that paperwork, we will make you the signer for this trust account because that's what the trust document tells us to do. You don't need a judge's signature because you've got a valid trust. You saved $4,000 and 2 months at least of going through the court process by having this trust. So that's a nice benefit there. I confess I also do probate administration, so I'm giving you advice that makes me poorer. Just so you know, this is the same advice I give my own mom, and I like my mom. So, 2 probate examples there. Let's talk about another reason to have a trust. Another reason to have a trust is that a trust helps keep your assets private. If you are or you're in a profession where you get sued a lot, doctors, for example. I don't know what it is, but litigation attorneys, they look at a doctor and they just see dollar signs. After you've been sued once, you don't want to get sued again. And one of the ways that you do that is you try to keep your asset information from becoming public record. But let's look at this first set of bullets right here. Usually, when you have assets that are not in the name of your trust and you pass away, those assets become part of the public record. When your estate goes through the probate process after you die, your executor is required to publish an inventory of your assets. So that's real estate, that's bank accounts, that's cars, that's boats, that's business interests. That's all supposed to go in the public inventory. So any really nosy kind of person can find it. The other thing about dying without a trust is that your will becomes a public document. So I'll tell you right now, if you go to Google and you put in Travis County Probate Court Records, you can search by name of a deceased person. And if they went through the probate court process, you can find their will. It's right there as a PDF. And if they've done an inventory, you can see the inventory too. So one of the benefits of the trust is that you've got no public inventory if you set up the trust correctly. You don't go through the probate court process. So there's no inventory to show. The trust document is typically not made public. It's not typically shown on the Travis County public records. And lastly, the trustee does not have a duty to be showing the trust to a bunch of people. In fact, the trustee is going to try to keep the trust away from people as much as he possibly can. I'm looking over on my other screen. I'm seeing I've got some questions in chat. I'm going to take a look at those. Oh, Al, I'll handle the beneficiary designation question later. You can shoot me an email on that one. Hannah, does every probate have an inventory? That's a good question, Hannah. The general rule is that when you probate a will and you go through the estate administration process because you need a judge's signature, right? This is when you need a judge's signature to access a frozen account. Your executor is required to make a list of your assets valued as of the date of your death and file it with the court, because that's the Texas Estates Code says point blank, you need to do an inventory. There are ways around it. There are ways to get around it. You can do an affidavit in lieu of inventory under certain circumstances, but you still got to do an inventory, and you still got to get that inventory prepared so it's possible that someone can get a hold of it. Good question, Hannah. I've got another question from Chris Wilson to everyone. For a single person, should the children be on the house deed? Chris, I'm not sure. Is this a deed to the kids after you're deceased? Is this a deed of the house to the trust? I'll let you answer that in the chat, and I'll come back. So now that we know that trust assets are mostly private, let's look at some examples, you guys. Okay, example time. Keeping trust assets private. Gus Gumshoes owns certain assets at death. Which assets are public if he dies? Which of these assets are public if he dies? Let's go to this first one. Gus Gumshoes dies with a checking account in his sole name and he dies. Is this checking account going to show up on a public inventory when he dies? What do you guys think?
Yes.
Yes.
Yeah, you guys are exactly right. It's exactly what we talked about, right? You've got an account that has to go through the probate court process when he dies because it's not transfer on death, it's not pay on death, it's not in a trust. So it gets frozen, and you go through the probate court process to get a judge's signature to access that account. That executor is going to have to do an inventory, and that executor has to disclose the checking account value on the public inventory. Okay, same Gus Gumshoes, he still dies, but he's got a checking account held in the name of his trust when he dies. So the checking account is in the name of his trust when he dies. Is this trust checking account public information when he dies?
No.
No.
Connie, I'm seeing you shake your head no. You're exactly right. Exactly. The difference here is that we put the account in a trust after he died. Hannah, that's good. I see you saying no. He put the trust account, he put the checking account in a trust before he died, assuming there is a backup trustee and his trust is set up properly. The backup trustee just shows up with the death certificate, proves, typically with the driver's license, that he's the backup trustee, and then the bank says, all of the paperwork checks out, we'll need you to sign some forms, but otherwise, we're going to do what the trust told us to do. You're the backup trustee, you're the signer now, we're not going to make you do a public inventory, no problem. Very good, 2 for 2, you guys. So, next one. Gus Gumshoes still dies. He has real estate in his name. He's got real estate in his name. Now that he's deceased, is that real estate public information?
Yes.
Yes.
I'm seeing 4 head nods on the screen. I love it, you guys. Yes. Hannah, you're exactly right. Yes. It's just like the original checking account, right? If it's real estate in his sole name, it's not in a trust, it doesn't have a transfer on death deed, it's just in his sole name. You know what? When they go through the probate court process to get a hold of that real estate, It's going to show up on the inventory. It's Schedule A, real estate, line item number 1. Here's the value of this thing. So that's public information. Here's the last one right here. Here's the last iteration here. Gus Gumshoes owns real estate in the name of his valid trust when he dies. Is this going to be public information when he dies? This is a trick question. This is really mean. This is a trick question. Connie, I see you smiling and nodding your head because you're exactly right. The answer is kind of yes, kind of no. It's no in the sense that because we've got a valid trust and the real estate was validly moved into the trust before Gus died, there's not going to be a public inventory saying, hey, Gus owned this real estate when he died and here's what it's worth. But remember, real estate has public records like real estate taxes. So if you or one of your friends is in a case where you really want to keep your real estate holdings private, that's where you get into more sophisticated asset protection strategies, maybe using LLCs to hide the ownership of just really nasty, mean people who just want to sue you. So that was really good, Connie. I saw you nodding your head, but yes, no, not quite. Very good. So we covered 2 big reasons why you want to trust. We covered avoiding probate. That's at least $4,000 in 2 months. We covered keeping trust assets private, especially if you're someone who people like to sue because they think that you got a lot of money. And third, we're going to go to the last one, and I think this is the unsung hero of a trust, is continuity of management. Continuity of management, especially if you have a lot of assets. You've got an investment account, you've got rental properties, you've got a house. If you have a trust that is properly established, your backup trustee, if he knows where the assets are, he just shows up with a death certificate and says, hey, I'm the backup trustee. Here's my driver's license. Make me the signer. He takes over and starts paying the bills pretty quickly. That's what we want, right? We don't want, just because you pass away, it's okay. You named a backup trustee. That backup trustee shows up, proves that he's the backup trustee, and then says, all right, I'm ready to start paying bills, taking care of this stuff. Remember what we talked about before. If you've got assets in your sole name when you die, typically those assets get frozen. Typically, you got to have a judge's signature to access those assets after you die. That could be a 2-month process, 3 months process with COVID, $4,000 in court fees and attorney's fees. So a trust, one of the big unsung reasons to get a trust is really your backup trustee can get a hold of the assets and start doing what you want them to do very quickly compared to going through the probate court process to get a judge's signature. Hey, you guys, we covered the 3 big reasons, 3 of the common big reasons to get a trust. If you guys want to stretch a little bit, get a drink or something, we're moving on to the next section. I'm very happy to see you guys on the screen, not falling asleep just yet. You won't hurt my feelings. I love this stuff. So let's get to some mechanics now. How do I set up a trust? How do I make a trust and make it start working now that we know what a trust is and the reasons to make a trust? First, we strongly recommend a written document. If you dig around, forgive me, if you really love this stuff and you dig around in the Texas Trust Code for a little bit, the Texas legislature contemplates verbal trusts, but we really do not recommend them. It's just a minefield because there's no way it's very difficult to prove the trust exists and to enforce it. And then you have vague memories. Written document is the way to go. And then once you've got a trust document, once you've created a trust document, you need to put assets into the trust. Otherwise, your trust is broke and it doesn't do anything. So you've got some examples here. If you've got real estate, you file a deed to put that real estate into the name of your trust. If you've got normal non-retirement accounts like checking accounts, savings accounts, investment accounts, you usually use a certificate of trust, which is a little summary of the trust, and an instruction letter. Usually your attorney prepares both of these things, and then you give those to the bank and they say, okay, we'll open up the trust checking account and we'll put whatever you want us to put into that trust account. And then the last one is, and this is the tricky one, retirement accounts, life insurance, and annuities typically are controlled by beneficiary designations. So you typically want to do a beneficiary designation that says, I want you to take this retirement account and distribute it in a way that is consistent with my trust. Okay, you guys, I know that was a lot. Thanks for hanging in there with me. Let's do some examples, okay? Let's do some examples. I hope these guys look a little familiar to you. We got the same situation. Setting up a trust, example 1. Anakin says to Ben, please hold my lightsaber for my son Luke until he's 18. Is this an enforceable trust?
Maybe.
Yes, that is a very lawyerly answer, whoever said that, maybe. That's a very good lawyer's answer. The other one is, it depends. Isn't that infuriating? But I'll tell you what it depends on. Even though, if you get a good litigator, you might be able to argue that this verbal trust is enforceable, I would not bet money on this. I would not hang my hat on this. Because imagine all the things that can go wrong. Ben could say, Anakin gave it to me as a gift. To me. It's not for Luke. He gave it to me. And possession is 9/10 of the law. Too bad, so sad. And then you've got an arguing contest. Luke says this. Ben says this. Anakin might be dead. So you have all sorts of evidentiary problems. So although theoretically this might be enforceable, dollars to donuts, if I were advising my own mom and I like my mom, none of this verbal trust business. We're going to do a trust, we're going to get it in writing. That's the way to do it. I like that. That was a good answer, whoever said that. Setting up a trust number 2. We got Scarlett O'Hara again. Okay, assume we've got a valid trust. Okay, so there's no question this is a valid trust. I leave my plantation, Tara, to my daughter, Scarlett, for her lifetime with money sufficient for its upkeep. You guys, I'm going to tell you, this is a really nice grantor. Whoever this guy is, I like him a lot. Scarlett should like him a lot too. She shouldn't run off with this guy, Rhett. Oh, but the grantor's will says something different. The grantor's will says, I leave Tara, the plantation, to this guy, Rhett. Who's Rhett? Who's this Rhett guy? Father never deeds the Tara plantation into the trust. He doesn't file a deed. It belongs to him when he dies. Father dies. Who gets the Tara plantation and why? I see a smirk from you, Connie. You know something is fishy going on here. Al, I see you thinking about it. I like that. I like that. I'm going to hold you guys in suspense for a few more seconds.
Seems like the valid will would exceed the trust. I mean, excuse me, the valid trust would exceed the will.
Al, thank you for being brave enough to submit an answer. I really appreciate that. I deliberately made this question kind of hard, right? Because I said we've got a valid trust. So that kind of leans towards the trust, right? But we've also got a valid will, right? Here's the kicker here. here is why setting up the trust properly is so important. The kicker here is that the trust does not own the plantation, right? We never moved the plantation into the name of the trust.
Okay.
The way that the title company is going to think about it is they're going to say, we don't care about your intention. We care about what the documents say, because it's a valid deed that transfers title to real estate. In this case, if the real estate had been in the name of the trust could control it. But look what we said here. Father never deeded the plantation into the trust. The trust cannot control an asset it does not hold, right? We never deeded the plantation into the trust. So when you die and you own an asset in your individual name, the trust doesn't help you because you never gave it to the trust. So it's the will that controls. The plantation goes to rent.
Oh, shucks.
Ginger, I just look, if you look in the chat, Ginger's question is fantastic. Are we assuming we're in a year that allows women to hold property? Okay, high five to you on that one, Ginger. I acknowledge I might be getting the time period wrong on this one. That's a great question. Okay, very good, you guys. Very good. All right, so now that we've talked about the importance of setting up your trust properly, you've got a trust, it's in writing, and you moved assets into the name of the trust by deed, by cash, with trust checking accounts. Very important, because you know your trust can't control assets it doesn't own. You need to move your assets into your trust or make them consistent with your trust. Now that we've got that, another issue for your trust when you're setting it up. Selecting your trustee. Typically, what you want to do is choose someone who is very responsible, who is good with money, good with paperwork, and good with communicating with beneficiaries. Because the trustee is the one who's holding this money, right? You don't want someone who's just going to run off with it and just blow it at Vegas. I add a note here. For a lot of people, what they do is they choose a close family member or a friend. And that's really good because usually you're leaving money to family members. So that makes sense. If you've got a responsible family member, use them. That's great. I mentioned an institutional trustee right here, like a bank. Sometimes you really do want to bring in a professional trustee like a bank that does this for a living, because sometimes you've got cases where you've got very complicated assets that require a lot of work. Some people have big ranches, oil and gas interests, and those things can be a lot of work to manage. So sometimes it's just better to let a professional do that. Or sometimes you've got how shall we say, a difficult family situation where the beneficiaries are fighting each other all the time. So sometimes it's nice to have an institutional bank trustee to just be in the middle and let them yell at the trustee, let them yell at the bank and not each other. So that's selecting your trustees right there. So now that we know about setting up your trust, put assets into the trust, and then choose a trustee, the next question becomes, all right, you guys, this is a very sad topic because most of the time when you're writing a trust, the grantor is your client. So when does the successor trustee die? It's usually when the original trustee dies, becomes disabled, or resigns. So that's when you walk off to the sunset and the new trustee takes over. So that's typically what triggers old trustee steps aside, new trustee shows up. So now that we've got a new trustee setting up, taking over, what does that trustee need to do? What does the successor trustee need to do? You gotta find the trust assets, you guys, because as trustee, you are responsible for managing those assets. So you got to go find them and get them. The trust typically has some bills to pay. You know, if you've got real estate in there, you've got insurance, you might have a mortgage, you got real estate taxes to pay, you got to pay those things. The successor trustee needs to talk to the beneficiaries and say, hey, look, you might have heard through the grapevine that you're a beneficiary. I'm going to send you a copy of the trust, and here's what the trust tells me to do. So I'm not coming out of left field here. I'll tell you what I'm going to do. I'm going to do it. I'm going to remind you exactly how I'm going to do it. And then finally, the trust document will tell the trustee, hey, you need to make some distributions, okay? So that's why these two bullets are together, because the trustee needs to talk to the beneficiary and tell them, hey, here's what you're entitled to, and here's how I'm going to get it to you. Okay, so we talked about a successor trustee's to-do list. Now let's walk through that specific process. Let's start with the easy one. Getting custody of trust assets. Typically, once you've found the trust assets, it's not too hard to get custody of them. Typically, what you'll do is you'll hire an attorney who will help you prepare a trust certificate and a letter of instruction that tells the bank, hey, here is a summary of the trust. You can check your own records. You'll see the same thing. And here is a letter of instruction telling you, I'm the backup trustee. Make me the signer. Usually this is not too hard because once you know where the assets are, you can typically get signing authority for them. It's not too hard. With real estate, typically if you've got a tenant, you tell them what's going on. There are other people involved like the insurance company and updating the address for the property taxes. But usually once you know where the assets are, it's easy to get custody of them as the backup trustee. That's the whole point of doing a trust. So I gave you the easy one first. Getting custody is the easy part. So what's the hard part? The hard part is finding the accounts. The hard part is, because imagine if you're the grantor, it's your trust, you know where everything is. That's no problem. But if you are deceased, how is your backup trustee gonna know where everything is? How is he gonna know where your assets are? So I'm gonna pose the question to you. Imagine you are the backup trustee for a trust. You're the successor trustee. How are you gonna find the checking and savings accounts? How are you gonna find the investment accounts?
Should be in a letter of instruction.
I got letter of instruction. Al, I see you thinking about it. I like this. I see a smile on your face. Yeah.
Take a look at my spreadsheet that shows the beneficiaries and the net worth of the estate.
Oh, perfect. So Al has already jumped 3 steps ahead. He's way ahead of the curve on this one. In a perfect world, the grantor has left a balance sheet of the trust assets for the backup trustee. They said, I know you don't know where the assets are. So I'm going to tell you. I'm going to leave a sheet of paper that tells you. Some people build a formal balance sheet with all the accounts listed out. Some people leave all the monthly statements. Some people leave business cards, right? Here's the business card for my banker. Here's the business card for my insurance guy. Here's the monthly statement for my rental properties, right? In a perfect world, it's just like Al said, your grantor is very, very kind and leaves a paper trail for you. If you don't have the benefit of a paper trail, here are the common steps you use to find the assets. Ginger, treasure hunt of clues. Yeah, that's not too far from the truth. If you look at chat, Ginger said, treasure hunt of clues? typically what you do is your first resort is you try to get into that person's mail and email account. So you just start opening up the mail and you start saying, is she getting statements from Bank of America? Is she getting statements from Charles Schwab? Is she getting real estate bills? Is she getting insurance bills? The next common thing that you look at is the income tax return, the IRS Form 1040. If you look on Schedule B, B like Bravo, Schedule B lists the interest and the dividends that the grantor is receiving. Typically, that gives you a place to start looking for accounts. If you're really lucky, the CPA will still have the IRS Form 1099s, and the IRS Form 1099s often have account numbers on them. So that's very helpful. And then the last thing, and this is the Hail Mary right here, is you file a credit report. You request a credit report for the deceased person. So that's Experian, Equifax, and TransUnion. And if you can get a credit report from those guys, they typically list every account they know about in the name of the grantor, and you can find out if those accounts are still open or closed. So Ginger, I mean, you're basically right. If the grantor did not leave you any information, you're hunting. You're really just hunting. I have seen people go through houses where the paperwork is stacked one desk after another, and those successor trustees, they are some hard-working people to go through that paperwork and try to figure out what's in the trust. All right, you guys. Ooh, how do my mouse is, there we go. Okay, next slide. So now that your trustee has found the asset, I never want to be a trustee. I'll tell you what. So I'm taking a law school class, my very first wills and trust class, and you want to know what the professor tells us? You know what he wants to tell us, all first-year law students? You want to know what being trustee is? It's not an honor. It's not a right. It is a job. No joke. It is a lot of work. So that's why we made such a big fuss earlier that when you choose your trustee, you want someone who's really good with paperwork and really organized. Hey, here's another unglamorous job of your trustee. I'm sorry, Clive. I know you're listening. You know what you got to do when you're trustee? You got to pay the bills. The trust assets have bills. There's a tax return. There's insurance. There's utilities. You got to pay those bills. So let me give you some examples, because I know I've been yakking a lot. Let me give you some examples and bring you guys back in. Example number one for paying trust bills. Trustee, and this is a valid trust, so the trustee is running things now, right? The trustee fails to pay for insurance on a house owned by the trust. The house is destroyed by a tornado. Connie, my ghost comes back to haunt him. So a cow flies through the house and destroys it. Do the beneficiaries have a claim against the trustee? Can they sue the trustee? Why or why not? Any brave souls?
They failed to do what the trust instructed them to do.
You hear that from Connie? They failed to do what the trust told them to do? Anybody? I see some furrowed brows thinking about it hard right now.
Said they do have a claim.
Okay, I'm going to give you a little more suspense, just a little more. Okay. My answer, I designed it this way to kind of lean against the trustee, is that the trustee, by default, has a duty to preserve the value of the assets. typically when you own real estate, you typically own property casualty insurance for things like hail, flooding, tornadoes, fire. I think the beneficiaries have a pretty good claim against the trustee in most cases to say, if you knew there was real estate and you didn't pay for insurance on that real estate, you may not have been the cause of the house getting destroyed, but you were negligent in not buying insurance on the house. So I don't know how much they would win. That kind of comes up in litigation, but you, as trustee, you never want to be in this scenario. You never want to put yourself in this scenario. If you've got valuable assets, you want to pay insurance on them to protect them. Hey, you guys, I love to see you guys. We're kind of coming up on the last 5 minutes. So I'm going to do one more slide because it's the last idea with this, and then we'll do some questions. Thanks for hanging in there with me. I'm glad you guys are here. Example number 2 for paying trust bills. We got a trust. We got a valid trust. The trustee decides, you know what? I'm not going to pay the trust income tax bill. I'm not going to pay it. I don't feel like paying it. Instead, he distributes the trust assets, all the trust assets, to the trust's sole beneficiary. I mean, the trust told him to do it, right? There's one beneficiary, and he paid the trust assets to that one beneficiary. If you know something about Uncle Sam, is that he likes to get paid. He may not be the fastest guy at the wheel, but he's going to get paid. Can the IRS sue the trustee? Can the IRS sue the beneficiary? Why or why not? This is a mean question. I can see this is a mean question. What does your gut tell you? Regardless of whether you like the answer, what does your gut tell you?
Beneficiary has to pay the
I've
IRS.
got one answer for the beneficiary's going to pay.
The IRS can sue the beneficiary.
The IRS is going to sue the beneficiary? Any other brave souls?
Because one way or another, the beneficiary is responsible for the tax.
You see that one comment in chat? Both get sued. Both get sued. You guys, the IRS can sue both of them if it wants to, because the trustee is personally liable for the debts of the trust up to the value of the trust. He had the money to pay the trust bills, right? He had it, but he gave it to the beneficiary. Just because he gave it to the beneficiary does not absolve him of the liability for the taxes. So IRS could come after the trustee, or it could argue, you know what, beneficiary, your right to that distribution was subject to the taxes. So we can come after you for it too. We'll sue whoever we want. So, Chris, you see his comment in chat, more money for the lawyers, oh joy. Hey, I'm on your team, you guys. I'm warning you about this. So there you see, in this case, trustee, you want to pay those bills. Pay them on time, pay them early if you have to. You guys, you made it through Successor Trustee School Part 1. I'm so glad you guys made it. Do you guys have any questions? I'll stay a little late for you guys. If you need to go, please feel free to go. I've got one question. How many parts are left and when are they scheduled? Let's see. We went a lot farther than I thought we would. We got to slide 27 of 38. we might have 1 or 2 more sections. We'll shoot out an email letting you guys know when the next sections are coming out, so you'll know. I've got a question in chat from Chris Wilson to everyone. LLC, you mentioned it before. When is it appropriate to use an LLC? Chris, that is a very good question, because oftentimes when you raise asset protection issues, LLCs are one of our first lines of defenses against getting sued. What I'm going to do is tell you that that's outside, I confess that's outside the scope of this presentation, but we've got 3 really good attorneys here who do LLC work. If you shoot me an email, I can pass you on to them and get you some really good advice from them. I'm going to put my email address here at the bottom. Okay, I got another question. Can I have 2 co-trustees? That's 2 co-trustees. Yes, you definitely can. If you're the grantor, you can construct your trust any way you like. A lot of times our grantors say, you know what, I got 2 kids that I really like and I trust them both equally and they're both good with money. In that case, you can definitely have them as co-trustees. The thing about co-trustees is you need a voting mechanism. So typically if you've got co-trustees, you've got 2 of them, they both have to agree on everything. I got another question. How can we get access to the recording? That's a great question. So at some point after this meeting, I think Allison or Megan is going to shoot out an email with a link to our YouTube channel when we've got this posted, so you can watch the recording on YouTube. I've got another question. Are the co-trustees equally personally liable for the trust? I think you know what I'm about to say, and it's not going to be a happy answer. The default rule, without additional facts, is yes. The co-trustees are both liable for the actions of the trust. Yeah. Being a trustee is no picnic. No picnic. You want tough, strong people as your trustees. I got another email. I got another question from Chris. I missed the first 10 minutes. Shame on you, Chris. Did you discuss the trust? Is it the same thing as a living trust or a revocable living trust? That's a good question, Chris. Typically, the type of trust we've been using as the example here has been a generic trust, but it fits into this mold, the revocable living trust, which is a trust that you, as the grantor, create while you're living, and you have complete access to the trust. You can do whatever you want with the trust while you're alive, and then when you die, that's when the successor trustee shows up and says, okay, now I've got to get custody of the assets and do what the trust tells me to do. Excuse me, itchy nose, itchy nose. Okay, you guys, any more questions? I'll stick around for just a little longer. Looking around. No questions, no questions. Some questions, slow typers. Okay, you guys, I think that's going to wrap it up for tonight. I'm really glad to have had you guys for Successor Trustee School Part number 1, especially those of you guys brave enough to throw out some answers. I really appreciate that. We will shoot out another email when Successor Trustee School Part 2 comes out. And a secret between you and me, we're going to be publishing a book, a successor trustee book at some point in the future that we'll let you guys know about when it's ready to come out. We're really looking forward to getting that out to you guys. Otherwise, I'm really glad to have had you guys here. I've got my email address at the bottom of the text box, Chris tcvlaw.com. Please feel free to shoot me any questions you've got or any questions you didn't want to ask during the slideshow. Otherwise, it's great having you guys. I hope to see you guys at the next one. Thank you, guys. I'm going to close it out.
We really appreciate your time. Thank you.
Thank you.